Okay, we're live. And we have 2 people already.
Is that us?
Oh, yeah, maybe it's just us.
We're one.
Yeah. All right, I'm glad we pulled a great large amount of people. Hopefully more join.
More than one.
Yeah. I mean, we're happy to take all the one person's questions. Let's see. Okay, chat is up. 2 people. We'll just give it a minute for people to join. Oh, great. There's someone. Hey, if you guys have any problem hearing us, just put it in the chat, okay? Probably gonna wait a few minutes until we get maybe, hopefully at least like 10 people or so, and then we could start going over the questions. We're gonna start with timelines because that's most of the questions I received, and I think it's at the top of people's minds. So, yeah. Tell us a bit about background and experience. Oh, well, we can answer that while we wait.
Yeah, sure.
Okay.
Go ahead. Yeah.
Yeah, so we both work for a firm called Lee and Associates. Our boss is Hanjun Lee. He's been in the EB-5 space for, I think he's coming up on 17 years.
Yeah, approximately. Yeah, he started from 2006
Yeah.
or 7. Yeah,
Mhm.
he's been an attorney since then. So he's very experienced in EB-5 field. He also filed the project side documents. Yeah.
Yeah, so between me, Shui, and him, how many cases would you say? I think you told me before about 500 post RIA, right?
Yeah, definitely. Since we work with our regional center very closely, and almost all of their EB-5 cases go to us. So post RIA, we have worked on like 10 projects from them, and each project probably like at least 50 to 80 investors, and some of them even have 100 investors. And the majority of the cases are filed by us.
And then, Shui, before you joined the firm, you used to do other areas.
Right. I also do like EB-1 to perm, H-1B, O-1, all the employment-based applications. I've experienced in those, and also some family-based case.
And then my experience comes from the immigration court. So I was doing completely different stuff, trial attorney stuff. So between the 3 of us on our team, we can pretty much handle almost any area of immigration law. I'd say maybe we should put a little bit of a tentative something on that, because in case we get really out there questions. Yeah, hi Jay. Yep, I'm the same guy. Yeah. Questionnaire in the group chat. Okay. Yeah, so we'll get to those questions. We now have about 12 people, so I think we can just start with the questions that were sent to us beforehand. So the first one is, a lot of people ask me timeline-related questions. So the answer is that there is no set timeline for anything. And I know that's tough to hear. When you ask attorneys or regional centers or brokers or whoever, they're always going to respond based on what the data is currently. But with USCIS, as they are nowadays, they're inconsistent, right? Now, what we are seeing right now is EAD. Well, let's just go. This is going to be mostly for India and China people. But EAD and AP, it can come together in a combo card, or they can come separately. If they come together, then you might get it between 6 and 9 months. If not, then EAD probably 6 to 9 months, and AP more than a year.
Right. It's just getting very slow recently since December last year. We don't know why. We don't know if it's a one-time thing or they're just changing their attitude towards EAD and AP. So it's just getting slower and slower. It used to be only 4 to 6 months, but now we're seeing like 6, 8 months. We don't know if this will get worse or this will improve. We just have to see. From our ends, we are looking at the investors who filed in last June or early July. They are getting their EAD approved.
And then moving on to 526E, I would say, yeah, it does differ between rural and HUA, that's for sure. Rural, I think it's a bit less than a year right now, but that's as they're being adjudicated. So if you file right now, it might not be the same timeline. And HUA has been very slow. I think the data was released a few months ago, and we saw that they're currently processing 526Es at the beginning of 2023.
Yes.
Yeah.
Also, based on our case, it's like April. The latest one we get any action from USCIS is from April 2023 HUA.
Yeah. That's without filing writ of mandamus, though. So there's pros and cons to filing mandamus, but we can get to that next because there were a few mandamus questions that we got as well. I-485 adjustment. I would say it's right now it's 6 to 9 months, but that's another thing that could slow down, right? Yeah. And then the IA-29 for post-RIA, it's kind of a relatively small sample size at this point. I believe over a year. Would you compare? No, IA-29.
Oh, 89. They're very slow right now, like at least 2 to 3 years. But that's based on current processing time. Maybe you'll get better when the time your cases are going through that stage. It could be different.
Yeah. We also got a question about how the first in, first out is going to work. That's being implemented on March 30th. So Suzanne Lizicki, she posted on her blog about it. There was a comment on the USCIS website. But basically, what they're saying is they're going to continue to prioritize rural. Things are going to be processed first in, first out, based on the approved I-956F. And then they said something like maybe they'll do something similar for the other categories. But right now, unfortunately, I don't even think they know what they're doing. I think they're basically just trying to prove that they're creating some kind of structure so that they can have a better response when they get sued with writ of mandamus, because the adjudication hasn't really been uniform. And I think this is just their attempt at creating some kind of structure. I don't know if things are meaningfully going to change, because the question is, all right, if you're going to go by I-956F approval, are you doing it based on the newest I-956Fs approved after the March 30th, or are you going back to how far back was the I-956F approved? So if an I-956F was approved 3 years ago, are they going to review those petitions first under the first in, first out, or will it be based on the one that was approved most recently after the 30th? I don't know. I mean, one way kind of makes more sense than the other, but they weren't clear on that. And with USCIS nowadays, they're just not very clear, and it leaves things up to interpretation. Okay, next we have some writ of mandamus questions. So we don't file our own writ of mandamus. We send those out typically. But we were asked, basically, well, with the first in, first out change, are we going to have to be a bit more wary of filing writ of mandamus? And I would say potentially, because I think now that they have a structure, USCIS has a better argument against being compelled to look at cases through writ of mandamus, because they can say, well, oh, now we have this first in, first out, and we have XYZ in front of you, so we're doing everything we can. Do you agree? Or
yeah, I agree. But in the past, although it's not written, but in the past, it's kind of also the first in, first out rule. It's just not in writing. But now they have something in writing, so maybe they will use that as a defense. Yes.
What are the current risks associated with filing writ of mandamus? Has there been a recent shift, and what should we expect? There's been a recent shift across all U.S. immigration, and that is increased scrutiny. Every single application is seeing it. It's just a factor of the current administration. Current risk, I mean, I would say that generally, if you do file a writ of mandamus, you may get more scrutiny on your 526E petition review. Would you say?
Yeah, definitely. From our experience, at least, the cases filed getting some response from USCIS after mandamus, it's generally more difficult to respond. They'll ask more tricky questions. They may ask for documents for like more than 10 years ago, 20 years ago that they know it's impossible to get, but they will still ask those kind of questions. You can kind of understand their way of thinking, like they're thinking, okay, you're rushing me, then I'll just give you something to work on so you can stop harassing me. That's probably how they think about the issue. That's why usually mandamus, you get RFE or potentially NOID, notice of intent to denial. And for NOIL, you only have 30 days to respond. For RFE, you have 90 days, so it will get very difficult to handle if you only have 30 days and they need records from more than 20 years ago. That's something you have to think about before filing mandamus. I think we only have one case, and it's at very early stage of people filing mandamus. Nowadays, a lot of people file mandamus, but in the past, just a small group of people filing that, and we only have one client that get a straight approval after mandamus. After that, it's either RFE or NOID. That said, we answer all these RFE and NOID, and they do get approved. So it's still possible to get cases approved after mandamus. It just depends on how you're building the response. If it's very solid, or they can still find ways to deny it.
Yeah, and I would say definitely talk to a mandamus attorney before you file. But yeah, you should expect more scrutiny. But for some people, they have a very straightforward source of funds, right? So it might be less likely to get an RFE if USCIS has a very simple job to do when reviewing the petition. Okay, we got a bunch of questions on the visa ban. I would say, I mean, I don't think, so the 75 country visa ban from like a month or two ago. I don't know if those 75 countries are really going to make a meaningful difference with visa allocation. And I know there's a lawsuit going on right now. It's the National Immigration Law Center filed a suit. So it's more of a pause than something that's permanent. I don't know.
Yeah, it's temporary so far. I mean, it's still there. So it could change things because a lot of people from those countries, they will file family-based cases. So the visas that family-based petition won't be able to use will spilling over to employment-based category. So the employment-based cases will get more visas.
Okay. Yeah. And again, I know someone was asking me if there's a lawsuit. So the National Immigration Law Center filed one. Actually, I don't think I can put that link in the chat. But you should Google it. It's pretty easy to find. The next question, do you think the midterms will affect USCIS adjudication moving forward? What do you think?
I don't know. It's hard to say. I think they are very busy. They have something to be more worried about than our EB-5.
Yeah, there's a lot of other things going on in the world right now. I mean, I'd like to think we don't know how the midterms are going to go, but if there's a radical shift and there's new leadership, then of course, we could see less scrutiny at USCIS. But I don't necessarily know if that's going to be immediate. Now, for those of you filing now, a big change in the administration coming in a year or two would probably be a good thing, I would guess. Yeah. What are the general concerns with exchanging currency from China? How can you do this in compliance with USCIS standards? And well, we can start with that.
Yeah, I mean, USCIS, they understand the problem of exchanging currency in China. They understand policy and restriction and everything. They get so many cases from China, and there are people in EB-5 industry lobbying with USCIS, so they know what's going on there. They generally will accept if you have friends and family, just exchange 50 USD every year for you, and then you pull all these money together to send for investment. They are okay with that. They actually have a policy, like an instruction training manual, and in that it specifically says they should accept that way of exchanging. And also some people use the currency exchange company. We also have clients using those. USCIS, they might issue our fee on the qualification of those exchange companies. So make sure they have the license and all the qualifications.
Someone also asked a follow-up on that. Can a regional center, I guess, own
no, we're not doing that. I mean, the regional center, they probably would not be able to do that. They do not want to be involved in this kind of thing. Maybe some of you have heard that there are regional center related loan that gets a lot of denials. So I don't think it's not a good decision to be involved in loan or exchange for a regional center to do.
Anything that's regional center affiliated, I believe at this point, for source of funds would put your petition at risk, definitely. And I don't know if you know this, but do you think it's better for basically non-Indian and non-Chinese investors to go in the unreserved category?
Yeah, probably. I mean, there are a lot of, for EB-5, it's majority is Chinese, Indian, and maybe Vietnamese. So a lot of unreserved slots are being wasted, are not used. So if you're not from these countries, I think you should consider choosing unreserved. Yeah. It's based on our clients' base. Yeah.
Yeah, so we did kind of answer the 70 question ban. Now we're moving on to the chat. Well, have you heard anything about visa spillover from that? I haven't really seen it pop up.
It won't happen so fast because the ban is this year. Any visa not used this year will go to the pool next year. Yeah.
And there was a lot of movement with EB-2. I heard speculation it might keep moving. I don't know where I heard that from, but it might keep moving. But I don't know. Have you heard anything about that?
EB-2?
Yeah, because they had a lot of movement.
It could be faster because of this spillover from family-based visa. Maybe it will EB-2 make it faster next year. I mean, probably this October. Yeah, it could get faster.
Let's see. Do you know how spillover works in general? I mean, either way, I don't know if it would be making immediate changes.
So the unused family goes to employment-based, and then unused EB-1 to 2, 2 to 3, and 4 to 5. But then 5 is complicated. Some of the EB-5 will remain in the same pool and to be used next year. Some of them will go to EB-1. That's the general structure.
Oh, well, he has a follow-up. Does it spill over to EB-5 as well?
2 to 3, no.
No.
Yeah.
Okay. How long is the 485 taking after 526 approval? How long after 526 approval do you recommend filing writ of mandamus? Well, we were talking about 526E approval earlier, which is 6 to 9 months. I don't know about the 526 because I know they have a much longer timeline for direct EB-5, just getting the 526 approved. I would assume that the 485 would probably be relatively the same.
45. Yeah, it's approximately the same. Yeah.
Yeah. And then, so they also want to know how long after that do we recommend filing writ of mandamus? Well, again, I would say talk to a writ of mandamus attorney because they're going to be more knowledgeable about what's going on currently. But I've heard that filing writ of mandamus for 485, there's been some pushback.
And we're not giving legal advice here, just sharing some knowledge.
Oh, yeah, just to continue to preface this. So everything we're saying is not going to be specific to anyone here individually. We're just sharing what we know generally across the industry. So yeah, none of this is legal advice. Thank you for the disclaimer. With the new priority processing, does filing 526E for project approval, does it give a big lead with approval times? Yeah, like we said, no one really knows. We don't know if it's going to be who gets priority. Is it the I-956F that's approved one day after March 30th, or is it the one that's approved the longest in the past? How are they going to organize this? How are they going to tackle this? We don't really know. Seemingly, there's going to be an advantage toward projects that have the approval. But again, that was kind of already the case. When can we stop relying on EAD and AP for travel and work? When can we stop relying on EAD and AP for travel and work?
When can you stop relying? I mean, if you don't have H-1B or any work visa, you have to rely on that until you get a green card.
Conditional green card.
Yeah, conditional green card.
Yeah.
Yeah, unless you have H-1B or L1.
Yeah. And that kind of opens up some other questions that people have, because I do see that come up quite a bit. Like, oh, I'm here on my H-1B when I have the AP. Which one do I disclose? Like, what's going to happen? Am I going to lose my H-1B if I disclose the AP?
I mean, if you're just disclosing it, it won't hurt your H-1B. You have to choose which one to use to enter to into the U.S. and which one you are going to use for I-9 when you're being employed. That will determine your status. Yeah, and then they will have different consequences. Yeah.
Okay. Does writ of mandamus increase scrutiny for the 485 as well? Have you heard of that?
I don't think so. I mean, 485, I would say majority of the clients, their 485 are very likely. I mean, there are no fatal things in the 485 for most of the people, unless you have criminal records or you have past immigration violation. For those of clients, maybe you may have some concerns, but for someone who always following the laws, no issue with immigration history, the 485, I don't think mandamus will do anything to a 485.
Okay. Someone said that they got a straight denial when they changed source of funds. They didn't really phrase it in the form of a question, but I think that's one of the new trends that is popping up for changing source of funds later on. So that's what people who interfiled. And there is some other things that could cause an additional trigger. I would say if you're using funds that you gained after you filed the initial 526E, and USCIS can see that, I'd say that puts you at quite a bit of risk. Just changing source of funds, I don't know if it'll always result in an immediate denial. It's one of those things with USCIS. Sometimes it's hard to know what they're going to scrutinize and what they'll pick out. What's the realistic timeline for getting conditional green card through for rural versus HUA if you file pretty soon? Realistically, it's hard to say because retrogression could kick in. I mean, it will kick in definitely at some point. And if you're pending, then yeah, that could certainly add years to the wait. I don't know if anyone has a realistic timeline. I mean, I guess some people are trying to do rural as soon as possible and try to get the 526E approved like right away with writ of mandamus, and then maybe be able to adjust on the 485. Maybe I think that's pretty tight, trying to avoid retrogression, but I think most people are going to end up waiting quite a while. I don't know if you have a number.
No, I don't have a number.
Yeah, that's the thing. Any benefits in investing in an infrastructure project? So the thing with infrastructure is these projects were very rare until maybe the past year, but the number is so low. It's like 200 people, and that includes family members, right? Dependents on the claim. So that number fills up really quickly, even though there's not a lot of projects using infrastructure. We don't really have data released. I mean, I was looking at Suzanne's blog about it, and I think she was saying there's definitely going to be similar retrogression for infrastructure.
Yeah, I agree. It's just very small percentage these are giving to infrastructure. Yeah.
Let's see. Now, that being said, I mean, are there any benefits to investing with an infrastructure project? I mean, that comes down to the individual project. I mean, maybe there is. I mean, we're not here to give financial advice. There could certainly be some sort of benefit, but that's not really for us to say. We're just speaking immigration-wise. Okay. Is there any hope in EAD and AP processing times reducing now that the gap after expiry and renewal is so long, it's useless? Right. I mean, I'd say that's been a very large complaint. And I think EB-5 kind of just got swept up. I think there was like a broad ruling that the administration wanted, and I think it was probably targeting people who are, pending asylum in immigration court, who were getting EAD, their work permit, and then EB-5 just got kind of included. I don't know if they're going to do any favors by putting it back to what it was, 5 years instead of 18 months. But yeah, I mean, given how long it takes for the EAD and AP, you're going to have to refile pretty soon after you get it, right? So that, I mean, it is a pretty significant issue. Does USCIS look at the source of funds at the I-829 stage? They're not supposed to, but they definitely are. That's something that we've been seeing, particularly with currency exchange cases. Yeah, I mean, everything is source of funds related is supposed to be adjudicated in the 526E. But because USCIS's standards have changed very recently with the administration, that when the I-829s come up, they've been looking back. And I mean, there's no telling if that's going to be challenged or if it has been challenged in court, but that's certainly what they've been doing. So if you're expecting your I-829 to be reviewed soon, then there's a good chance that they could look back on source of funds. If you use something like currency exchange or maybe an RC loan, it's possible. Do you have anything to add?
Not really. I mean, so far we're looking at those 829 RFE, looking at the source of fund are with with some like special issues with the case, like the currency exchange or like the salary they get from a company that is on some list, sanction list, or have lawsuits with U.S. government. Those are the cases they usually pick on to re-review the source of fund at a later stage. But we don't know by the time your cases are going through that stage if they will have more issue. And now they're using AI, so it's very easy for them to check.
Yeah, the whole AI thing is another whole can of worms, but maybe we can get into that later. Does USCIS currently assign one officer per EB-5 project to handle the 526E adjudication? If the project starts seeing approvals, should all the rest of the investors expect their approvals shortly after? That's a good question. I don't actually know.
I don't think it's just one officer. It's a group, it's a team. And I don't know if investor of one project will be assigned to a team or they just assigned randomly. That we don't know. But definitely not one officer, because that's too much of a work for one person to handle. And in terms of if one person's being approved, and not necessarily, it can take a long time for the rest of the investors of the same group to see some movements. Yeah.
I'd also say there can be wildly varying writing styles in the RFEs. So I guess that indicates that it's not just one person. Okay, so if we go EB-5 and we're moving along in the process with 526E approval, EAD and AP, but the EB-2 becomes current, can we cancel the EB-5 and select the EB-2? Can I withdraw my investment in the middle?
Yeah, I mean, this is not legal advice again. You can consider that, but you have to look if you are able to relink your 485 to the EB-2. Yeah, but that requires some attorney's judgment, but that's possible.
Yeah, it's possible. That's a good way to put it. Retrogression. Where does retrogression affect? Does it affect when you're getting your conditional green card, or does it affect when you're getting your I-829? The
conditional retrogression will affect the time you get conditional green card.
Is there a chance that I get my funds back before I get my conditional green card?
That's possible. Depends on the project. Yeah. Because under the new EB-5 rule, you don't have to wait until you get a conditional green card or permanent green card to get your money back. It's a difference between the new EB-5 rule and the pre-RIA rule.
When you say retrogression, what state? Well, we just answered that. What can we do if the I-829 is denied because they reviewed source of funds again? Well, there's a few things. First, you can try to appeal it or do a motion to reopen, which I think you've done appeals, right?
Yeah, we have some clients doing that. They file appeal after 829 denial.
But one thing that's changed is people who got I-829 denials are going to immigration court. But from what I've heard, the few times that people have gone to immigration court for a source of funds related I-829 denial, I guess the outlook is relatively decent, depending specifically on the source of funds issue. But I know there's been a few cases, Ron Klasko and Kurzban, I think, had a few between them, and they've been successful. Basically, immigration court judges don't know anything about EB-5. They really only know about asylum and things like cancellation of removal. So if you show up and you send them 1,000 pages of financial records, they're not really keen to do a 3-day hearing. So there's a good chance they'll just refer to the attorney who's arguing the case. And even beyond that, if a judge does rule against you, you can appeal and you can go to the BIA, and then if you lose there, then you can go to the circuit court. Okay. Are margin loans an acceptable form of funding? Well, we have to word this in a way that's not legal advice. So have we seen margin loans being successful? Generally, yes.
Mhm.
Does it increase RFE or denial chance?
Could be, depend on the loan, could be. USCIS, they're scrutinizing loan very carefully recently.
Mm-hmm. Yeah, it's difficult
That's
to
the
say.
trend, yeah.
It's difficult to say like what the percentage you could flag, but I mean, generally with any sort of source of funds, you want to go with places that have been doing this a while, that are backed, like that have legitimacy. I think that's one thing to consider at least. Can we switch from rural to HUA after filing the 526E? So I guess that's when a project is both of them, meets both qualities.
From rural to HUA, well, I don't think so, since on the 526E forms you have to pick, unless you pick both, maybe. If you pick both, maybe.
Mhm.
Yeah.
Recently, it seems processing standards have been very inconsistent. Is there anything being done? Can we file a complaint? Well, I would say what's being done is there's lawsuits, right? There's lawsuits against USCIS. Now, are they going to follow the rulings? I hope so. But that's really the only way to push back. Can you file some sort of complaint? I suppose so. I don't really know how much they're going to look into that. Anything to add?
Well, I don't think that's going to make much difference.
Yeah, I know there's a lawsuit about the whole RC loans. Yeah, so I guess we'll see. Yeah. Let's say if you had used some percentage of gift, can you return them back, or is the transaction being scrutinized? That might be a little specific. Do you see that question?
Yeah. I think this will, maybe we need to talk privately. Yeah, it's too much details.
Yeah. I mean, can the transaction be scrutinized? I mean, any sort of source of funds can be scrutinized at the IA-29 stage as of now. But yeah, we have to be careful about answering like very specific questions, as we could be seen as giving legal advice, especially if someone's already represented. Okay, well, we're about 40 minutes in, and I think we cleared all the questions. If anyone has other questions to ask, you can put it in. I'm just going to check some of the other places where I posted to see if anyone else wrote anything. But yeah, maybe we could wrap up a little bit early. Let's see. Oh, a few more questions coming in. Okay. Can we, if denied at the IA-29 stage, can we file EB-5 again? Is there any prejudice against us? I mean, yes.
Yeah, you can.
Yeah.
Maybe we'll consider change the source of fund
Mm-hmm.
and do it all over again.
Yeah, I mean, I don't think the fact that you've been denied at the IA-29 stage would necessarily be like the deciding factor for them to deny you again. If there is some issue that hasn't been corrected, then yeah, you might get denied for the same reason again. That's possible, but yeah, refiling is an option. Is there any sort of specific, well, they said Robinhood, but that might be a little too specific, but is there any, have you ever noticed certain companies and brokerages being targeted by USCIS? Not
No,
necessarily.
yeah.
Yeah. Okay. So there's a question about using income from rental properties. I mean, that might be a little specific. You can certainly use income from property. I mean, that's something that's been successful in the past. You just have to show, that the source of funds are valid, like how the property was purchased. USCIS, they might want to dig into it, I'd say. Yeah. If you get an RFE, does the EAD and AP expire? They said noodles, but I assume they mean maybe Noid. If you get an RFE or a Noid, does the EAD and AP expire too?
No, it's separate. Yeah, 526C is 526C, and AP and EAD are under different applications, 131 and 765.
What changes might happen after the grandfathering deadline? Well, it's pretty much all rumor now. I mean, probably the cost to do EB-5 will go up. I've heard the number for TEA. I mean, this is just a rumor. I heard 920, but it's impossible to know. I mean, there's a good chance they're going to increase it. They might change how long the funds need to be at risk. And certainly other rules might change, but that information is all just rumors that we've heard, unless you have anything that you heard different. Yeah. Any public info for which projects and how many members have the 526E file or how many 485 from an RC? I think that's something that you have to ask each individual regional center. I think they'll generally share that data with you if they have it. I don't think there's like a public sheet that tracks all this. Yeah, I mean, you could also talk with FINRA brokers who maybe they have a bit more project side knowledge on the data if they've had a lot of clients across multiple projects. But yeah, that's probably where I'd go for that. Okay. Yeah, I think that's it, unless anyone, oh, more, okay. Do you see EB-5 investors in the US doing adjustment of status get more scrutiny over those outside doing consular processing?
I don't think so. I mean, they are under very similar regulations. It's just being enforced by different officers. Well, it also depends on your personal situation, like your past immigration history. So it's hard to give a general answer on this. Yeah, you have to look at, your condition then to decide which route you go for.
Okay. All right. Maybe we'll give it another couple minutes to see if anyone has any other last minute questions, but I hope this has been helpful. I'm always happy to answer questions that we're legally allowed to answer. But yeah, okay, I'll give it another 2 minutes before I close the chat. Yep. Do you have anything you'd like to add?
Not really.
Oh, we do have more questions. Okay. Say you get your AP, but not the CGC, and you're still on H-1B visa. Okay. Let's say you get your advanced parole, but not your conditional green card, and you're still on the H-1B visa without the stamp. Is international travel possible? I mean,
Yeah, you can travel on AP if you choose to use that, but you also need your EAD if you want to work.
Okay, yeah, because she said, but can you return on the AP but still maintain the H-1B after using it?
You have to choose. You can maintain two status at one time.
Mhm. You're welcome. You're welcome. Thanks for joining. Can a project have a different PPM for different investors? Is that allowed? Or all the investors must have the same terms and conditions, year of investment rate, return, and so on? I mean, I think it can vary.
I think they will have one standard document which are filed with USCIS, but maybe every investor they will have like a side letter, but it has to be lawful. You know, you can't say anything in the statement that run against the rules, but maybe you have different agreements on the interest, or like some certain things legally allowed, you can put in a side letter. But for the standard documents, it's the same for everyone.
Yeah, I was gonna say, I think they just vary on maybe ROI might be different, admin fee might be different across different investors. Let's see. But yeah, timelines should be the same for everyone. When entering the US, I heard sometimes it's possible the officer at the entry is not aware of advanced parole. Is that common? What do you do then? Well,
yeah, we've heard from clients that they get a difficult time from the officers. Some of them, they may not understand AP. But I will say, like, from international airports, the officers there, they know AP. It's for like a small port of entry, or when you come by driving through the border, maybe the officer not familiar with AP. But for larger airports or port of entry, they are aware of this. But they could give you a difficult time. They could pull you into the secondary inspection. They have to review the case status of your 526E or 485 to make sure that AP is still valid. But most of the time, eventually, they will let you come in. It's just, it could take some time, maybe hours. Yeah.
okay. All right. I think that's probably it. So if you have any other questions, you can feel free to reach out. I think probably most of you are in the WhatsApp group or the subreddit, so you know how to get a hold of me. You could also go through our website if you want to schedule a consultation, or you can just ask me directly and we can put one together. But thank you everyone for joining, and we'll keep this video up on YouTube. We have one more question. I don't know. I don't know if I've heard of that. Have you heard of that? Some kind of memo?
Yes, that's possible. You can come on AP when you're on H-1B. You can travel. You can to travel abroad using AP. Yes, but the thing is, every time you enter the US, you have to pick either use AP or use H-1B. Next time when you enter, you may go back to H-1B, but it depends on the case, depend on H-1B case. But that is allowed. That's what I was saying. You have to pick one when you enter, but later you might be able to switch.
Okay. Well, thank you everyone for showing up. Thank you, Shui. All right, take it easy, everyone. I'm going to end the stream. Okay. All right, bye-bye.
Bye. See ya.